Thank you all for having us here today. This subject could be fairly dry, but we're going to try to lighten it up a little bit. Try to scare the heck out of everybody if you're not already scared about what can happen to you under contract terms and conditions. This is an area that I have done drafting, negotiation, and substantial litigation over the last 30 years. Almost all of my work involves contract disputes of some kind, whether it's oil and gas related or other types of disputes that you can imagine. And not surprisingly, in every contract, there are risk shifting provisions that benefit one side or the other. And if you're not keenly aware of those, it can really cause a tremendous amount of problems for your company. My title for this is How to Avoid Destroying Your Company Every Time You Sign a Contract. And literally on the provisions that we're going to touch on very highly, or at a very high level, you're going to see what some of those potential problems are. I'm going to give you some real life examples. I'm going to tell you about a few areas that you're probably not aware of that are virtually brand new. And as we go through the process, we're also going to hear about how insurance coverage can help shore up areas that you might have exposure on. So I'm looking forward to talking to you. Let me just say from the outset that I would not be a busy litigator if it weren't for the fact that my clients regularly do their own brain surgery. I know for those of you who are general counsel, you have trained and you have spoken to your purchasing department and various other people. Please, whenever you get a new contract, run it by your contract specialist or the legal department so we have a chance to look at it. Unfortunately, that too frequently doesn't happen. And as a result, provisions get in contracts where you have a dispute that can cause catastrophic results. Never sign a contract without reading it. Seems patently obvious, but it happens all the time. Always have someone who is familiar with that particular type of contract review it. Many times we see conflicting contract provisions between, for example, a master service agreement and a particular purchase order. You'll look on the purchase order and the fine print on the reverse side, it'll have a very different venue or dispute resolution procedure, or it may have something pertaining to indemnities that's completely different than the master service agreement. Sometimes the master service agreement will say, in the event of a conflict with other agreements between the parties, this will control, but sometimes it doesn't. So it's very important to make sure that all your contracts relate to each other, and if there's a problem that you resolve it. So we're going to talk about this, what I believe is the central issue in contract interpretation, and that is how various provisions shift risk from one party to the other. Who bears the risk? At what moment in time do they bear that risk? What are the circumstances? Do we understand the risks as contractually written? And has there been some new case or some new statute, as we're going to talk about today, that completely undermines an existing provision that you have?
I figure 75% to you, Panama, and 25% divided between the five of us. Gina, Crowbar, myself, Tom, and the baby. That makes 5% for each one of us.
No, Billy, you're cheating yourself. If there's 25% divided among the five of you, That's 14% apiece.
Oh, no, listen, Pop. I wouldn't cheat you. You know I wouldn't. Now, look here. I'll show you. Let me rub this out here. And now, 25 divided by 5 is 5. You see, the 5 won't put it 2, will it? No. But 5 goes into 25 5 times, you see?
You're wrong, Billy. Now, I'm pretty good mathematician. Now, 5 into 25, 5 won't go into 2, will it?
No.
But 5 goes into 5 once. Now, we didn't use the 2 before, so we use it now. 4 times. There you are. 5 into 25, 14.
No, look, Bob. Now, let me prove it to you. Now, that multiplication. 5 times 5. 5 times 5 is 25.
I'm surprised you're learning.
Huh?
I'm surprised that you're learning. Now I'll show you. 5 times 14 is 25. 5 times 4 is 20. 5 times 1 is 5. 25. That's it.
Oh, Bob. You're wrong there because I'll prove it to you. We'll put down 5 14s here. 14, 14, 14. There. Now I'll prove to you by addition that 5 14s is not 25. 4, 8, 12, 16, 20,
21, 22, 23, 25. Billy, I want to see you boys cheated.
I'm probably the only person here that remembers Mom, Pa Kettle. There were some great movies, and it just shows what you think is obvious, somebody else might not. There's at least 7 basic provisions that I focus on every time I look at a contract. And they're pretty much in this order. The very first is always indemnities. Risk of loss is second. Third is provisions limiting damages that can dramatically help or harm my client. Venue and controlling law, dispute resolution procedures, insurance, and confidentiality. And I didn't put insurance at the bottom because it necessarily belongs there. It's the one that y'all advise your clients about. And we're going to talk about how your insurance agent can help you make some really important decisions on what to do to protect your company. The clauses that we see in a lot of these provisions, especially indemnities, and there are almost as many indemnity provisions as there are contracts. Can seem mind-numbing. Each side has its own interpretation. As this guy tells this other gentleman, there's no need for confusion. Part 95, Section 3 of Article L clearly states, and that's what we look. That's the way it is with indemnity provisions. You can spend days and sometimes weeks negotiating indemnities just because so much turns upon how you shift an indemnity one way or the other. As I said, it's always the first term that I look at, and there are various basic categories of indemnities. Talking about commercial transactions where there are buyers or sellers, typically you will see a provision where a seller indemnifies the buyer for the seller's fault. Sometimes you'll see a very onerous type of provision, one-side provision where the seller indemnifies the buyer for not only the seller's fault, but for the buyer's fault. Seems counterintuitive, but we'll talk about that extensively. And then there's something that we're seeing a whole lot more because of various statutes that have come up, which is knock-for-knock indemnities, where they're reciprocal or mutual indemnities, where each party indemnifies the other regardless of fault. And I know that y'all have some thoughts about this too.
So one thing about a knock for knock, thank you. In looking at knock for knock, inherently you think it's equal balance. But in many cases, I see instances where we may have a customer that might have two people on site, say a directional drilling company may have 2 or 3 people on site, where the driller and a balance of the service crews may total a number of 50. So as a company with fewer employees, less exposure, is indemnifying the entire contracting group of the operator, I don't see that as being equally yoked. That company's taking on, in my view, more exposure. So my thought is, be mindful, don't just dismiss knock for knock as being a good thing. I would recommend you peel it back a little bit further and think about the context of your exposure to everything that's going on at that particular site and location.
It's a great point, and I'm going to give you an example of one of those contract provisions for indemnities that we see all the time. Because of the one-sided indemnities that I mentioned a minute ago, where the seller is indemnifying the 800-pound gorilla, not only for the seller's negligence, but for the buyer's own negligence. Various states, particularly the states that have substantial oil and gas operations, have legislated various anti-indemnity acts to protect the little guy. The courts have referred to these one-sided agreements as contracts of adhesion and against public policy. And there was a case in 1987 with the Texas Supreme Court in Ethel held that if you're going to have such a one-sided indemnity that is outside the purview of these oil and gas anti-indemnity acts we're going to talk about, these provisions must be in bold. They need to be in all caps. They need to be very conspicuous so the little guy knows exactly what he's getting into. And the terms need to be clearly expressed within the 4 corners of the agreement. Again, both the express negligence rule and the anti-indemnity acts that really have resulted from that 87 case are designed to protect the little guy where there's a huge disparity in bargaining position, and they bar the right of indemnity except under very limited sets of circumstances. There are at least 4 states now that we're going to talk about that have specific anti-indemnity acts for the oil patch, and these pertain only to work that is directly related to the oil well. It's not other field type services. It's not someone who may come and deliver and take things to and from a particular well site. It's almost like if you can get what we call a mineral lien against a well, that same party is entitled to protection under the Anti-Indemnity Act. And I bring Louisiana into this discussion because I think it's a classic clause explaining what we're trying to do in terms of protecting the little guy. It says that provisions in any agreement affecting oil and gas and other types of minerals or water are void and unenforceable to the extent that they provide for the defense or indemnity of the indemnity, which is the party receiving the indemnification, against loss or liability for damages. This can be property damages or personal injury or death, which is caused by or results from the sole or concurrent fault or negligence or strict liability of the indemnity. Again, that's a long way of saying that the little guy indemnitor will not be forced as a matter of law to indemnify the big guy, the indemnity, for the indemnity's own acts of negligence under these anti-indemnity acts, and we'll talk about some of the exceptions to those.
Hey, Randy,
Yes.
might I add something on
Please.
Louisiana?
Yes.
Remember in Louisiana, it could be the other anti-indemnity states, if you allow an additional insurer to be endorsed onto your policy in Louisiana, there must be a charge for that additional insurer, and we, as your agent, must bill that additional insured premium directly to that additional insured. It cannot be paid by you, it cannot be processed to you. It's just a reminder, because sometimes we have clients go, just send me the invoice, we'll take care of it. That's not allowed. It has to be a true transaction between we, the broker, and the additional insured.
It's a great point, and I know that almost every contract that you get requires that you add the bigger guy, the general contractor, or the owner as an additional named insured. People tend to see that as a no risk, no cost proposition, when in fact it has very real cost and risk associated with it. The 4 main states that currently have anti-indemnity statutes are Louisiana, Texas, New Mexico, and Wyoming. And again, they don't apply to general oil field work. In contrast to the other 3 states, Texas expressly limits, or strike that, I was not supposed to say strike that. Sorry. Texas expressly permits limited insurance coverage or indemnity agreements that are the so-called knock-for-knock indemnities, where they are supported by equal amounts of insurance coverage on both sides. So while it doesn't necessarily provide a liability cap for other areas, in terms of indemnities that are stated in the indemnification provisions, those parties can have these knock-for-knock indemnities as long as they agree upon a certain amount of insurance that they can provide for both sides in the event that the indemnification clause is triggered. And we're going to talk about one of the exceptions under Louisiana law in a second. This is just one part of a knock-for-knock indemnity. It's the contractor side of the indemnity. There's a mirror image of this from the company to the contractor. But I want to point out the point that was made just a few minutes ago by my colleagues here, that most of these knock-for-knock indemnities not only involve you indemnifying the company, the 800-pound gorilla, but they have any other contractor that the owner has or company has, any other subcontractor, agent, invitee, parent, co-owner, co-lessor, partner, subsidiary, or affiliate. These are people, you don't know who their names are, you've never met them, you have no contracts with them, but if you sign this type of knock-for-knock indemnity, you are indemnifying not only Baker Hughes, but every other Tom, Dick, and Harry company that they're affiliated with. And likewise, you are indemnifying them from damages not only that are incurred by the contractor's employees, but your subcontractors, your parents, owners, co-ventures, co-lessors, et cetera, et cetera. Some people get around this, or at least provide them with some additional protection by incorporating comparable contracts all the way down the chain with their subcontractors. I'm telling you, though, that many subcontractors cannot afford to have the types of insurance coverages that you see at the level of this knock-for-knock indemnity. So again, it's very important to make sure that you're not indemnifying the world and to try to negotiate this down to parties that you have some reasonable understanding what your risk is. Does the knock-for-knock indemnity concept apply where there is no oil field anti-indemnity act? And the answer naturally is it depends. Most states do not have anti-indemnity provisions. The ones that do, many of them strictly prohibit indemnities of any kind. Ohio is an example of that, so you can't, and Ohio is an area, as you know, with the Utica shale play, and many of our clients are active in that area, is a very, very big player now in the oil and gas business, but they have no knock-for-knock indemnity provision. Any kind of indemnity that one party has with the other is statutorily prevented. And then Louisiana has what's known as the Marcel exception, which can be very tricky, and I thought y'all might want to talk about that as well. Does anybody good? Essentially, the Marcel exception has to do with if you're going, it allows indemnification in the oil patch, and it allows so-called knock-for-knock, where there are insurance coverages on both sides, where the indemnity or the gorilla pays for the little guy's insurance coverage in order to basically, if they want this additional protection by having the indemnitor indemnify the big guy for their own acts of negligence, it requires that under this particular exception that you have to pay for the little guy's insurance coverage. Does that sound like something that y'all get into in your policies?
To me, the Marcel exception is as much about process as it is about getting the wording right, because if you don't get the billing straight, it will be voided, and it can be a pretty disappointing outcome for the parties involved in that contract.
It's a good point, John. So we've got these 4 states that have got very clear-cut anti-indemnity statutes that are focused on the oil patch. We have a few states that have some general anti-indemnity statutes where they don't allow indemnification of any kind, and then there are many states out there that have no statutes whatsoever when it comes to indemnification. So that's you really need to look at what state's law is going to control, and we'll talk about that in a minute as well when we get into jurisdiction. Indemnifications could not be a bigger issue in the oil patch in particular than they are right now. The McCann well, which is one of those company-ending catastrophic events, has caused everybody to reconsider the impact and what can they do post-McCann to shore up their protections. One of the issues was whether or not BP was required to indemnify Transocean and Halliburton for compensatory damages related to the oil spill. At stake was $40 billion. Fortunately, BP is good for it, but many companies could not withstand that kind of hit. The scope of the indemnity clause was everything in the judge's determination, and Judge Barbier held that the indemnity obligation, and this is critical, is separate from, it supersedes the rest of the contract, including the insurance provisions. So you have an indemnity clause that's within a contract, but that indemnity clause is considered a standalone provision by this federal judge that trumps all the other provisions in your contract. So if you think that you're protected, perhaps through your insurance coverages, maybe not. And that was clearly what happened here. The The court held that BP was required to indemnify Halliburton for third-party compensatory claims that arise from pollution or contamination, even if Halliburton's gross negligence caused the pollution. And I don't know if y'all want to talk about some of the post-Macondo indemnity issues that come up. I know you have some customers that for which this is a big deal, like Anadarko and so forth.
Well, the next few slides we've included here is following the Fifth Circuit ruling. In effect, I'm sure most of you are aware of what was handed down in the decision. But effectively, the Fifth Circuit said that the indemnity provisions do not govern the scope of cover available to the additional insured or that available to BP. So effectively transferred BP's rights to the policy, and the policy itself governs the scope of coverage rather than referring back to the indemnity provisions within the contract. Well, as a result, what we've included here, this is one of the definitions. 3 definitions were changed by the London market. And the London form, some of you may have this form already, you may have seen these changes. But effectively, what the London market did was make amendments to the additional insured provision, defense expenses definition, and the definition of an insured contract. This is the additional insured definition. The following 2, or the other 2 follow as well. Obviously, they're included in your packet. You can have a read. But what the London market has attempted to do, and of course this won't be known until it's ultimately tested in court, but the London market has attempted, through amending these definitions, to relate the scope of cover available to additional insured to exclusively what's in the underlying operating contract, thereby shoring up, I think, what was the belief of myself and many risk managers, that the indemnity provision should govern the scope of cover that's offered through the policy. After all, I wouldn't think that many risk managers, or at least the risk manager of Transocean, thought that he would buy full form cover for his customers, BP, etc. I just don't think that was reasonable. So here are the London market's views. There is one other bit that they've changed, and that's the choice of law for policy disputes. Prior to the Fifth Circuit ruling, choice of law was relatively open and easy. If an insurer preferred New York, that was fine. Many of our insurers preferred Texas law because they felt that Texas law had a more mature view of oil field risk. But I think the London market took a view that Texas law, given the Fifth Circuit ruling, exposed them too much. So what they've begun to do is insist on policy disputes becoming subject to New York law. Ultimately, I believe where that can create a problem is where punitive damage coverage in a form, and particularly the new London form, is silent. Under New York law, punitives are not insurable. So if you were to have some sort of policy dispute with your insurers and related to punitive damages, you'd have to take it to a New York court. I'm not sure that worked very well. So that's a point that I'd recommend that be discussed in advance of renewals or reopened, if that's the case right now within your programs, to at least analyze it and see what can be done. There have been some amendments made where punitive damage disputes relate back to Texas law. It's just that little window shop where some underwriters have agreed to that type of amendment.
Thank you. So you can see how just a few words can have a dramatic effect on what kind of risk your company is buying when they enter into a particular agreement, and that there is still risk because we don't know necessarily what New York or Texas court is going to do, or a court of appeals is going to do in a particular case. The second clause that I typically look at are any specific risk shifting provisions entitled risk of loss is normally what I see. This is an area where, particularly where you're dealing with the sale of goods and perhaps services that the UCC, Uniform Commercial Code, or the Texas Business and Commerce Code in our state comes into play. The old rule used to be that the party that held title to the goods at the time of the loss is the party who shouldered the burden of the loss. This is really important, for example, when we're talking about contracts of affreightment, where we're shipping goods overseas, and we'll get into that in a minute. The new rule is that title to the goods at the time of loss is completely irrelevant. Instead, what the UCC looks at is the contract clauses. If the contract places upon the seller the obligation to ship and deliver, for example, then their obligation is to preserve and protect the goods, and they're responsible for any loss that occurs or damage prior to the point that the goods are delivered. So if you have a contract that ships goods from the Port of Houston, let's say they're manufactured oil tools, to Angola, until they get to the Port of Angola, or if the delivery point is Exxon's particular oil field in Angola, then you're good, you're on the hook for any kind of damage up to that point. I know that y'all wanted to talk a little bit about marine cargo coverage for that.
Just real briefly, as risk managers, we typically focus on just the indemnity, but obviously the risk in handling assets and responsibility for assets and shipment and on the job site can be fairly devastating in and of itself. So please expand your reviews, obviously, to those aspects. But that's something we typically handle in our marine department, for example.
Three additional factors besides the contract, or strike that. Once, I'm sorry. Two additional factors, in addition to the parties' agreement, that are relevant to this particular determination under the UCC are whether one party is in breach and the moment in the transaction when the loss occurred. Obviously, if a party is on the hook until delivery, the moment is any moment until the goods are handed off to your customer. But if a party is in breach of the contract, that can shift the burden of the loss to the party that's in breach. International commercial terms are the third area that I typically focus on. They're called Incoterms. They're the shipping terms that the parties agree to, and they can have a huge difference. There are about a dozen different internationally recognized commercial terms. The one that we see all the time is free on board, or FOB, which basically means, or X works, that the risk of loss shifts when the buyer picks up the goods, and maybe they're using a third-party carrier to pick up the goods, but at the seller's factory. So if something happens on the road, it happens on the high seas, it's the buyer's problem. So that's another area in addition to the risk of law provision that has to be looked at to make sure that there isn't some other end around, and perhaps it's in the purchase order, perhaps it's in the bill of lading or something else that will shift the burden away from the seller to the buyer, or vice versa. There are several really important provisions pertaining to the limitation of damages that we want to look at every time we look at a contract. One is liquidated damages provisions, or so-called LDs. Another is a limitation on damages, often referred to as a liability cap, and then the exclusion of incidental and consequential damages. Liquidated damages are those damages that the party agree upon in advance. If a certain thing happens, that the party that causes the problem will have to pay a certain amount of money. A classic example is referred to as delay penalties. You've got a contract where, as the manufacturer, you're supposed to deliver certain goods to the owner. Let's say it's Vetco to to BP. And you're given a delivery schedule, and you have certain liquidated damages or delay penalties that attach to every one of those delivery dates that you bust. And unfortunately, many of those dates may be beyond your control. You may have subcontractors that are causing the problem. There may be third parties completely unrelated to your contract. Maybe it's that the ship that's supposed to deliver the goods is late. That will cause you to bust those particular provisions. But that may give you some negotiating room that doesn't get you out of the liability per se, because you're saying that if we don't meet this strict timetable, we will pay blank amount of money per day, per week, per month. And the amount of money can be in the millions of dollars. So it's one of the things that has caused manufacturers in particular to push that pressure downhill. As they say, crap flows downhill. And this is an area where that's particularly important, where if you're the last party in that contract with the owner, you've got to make awfully damn sure that anybody else that affects your delivery date meets their deadlines. Damages can only be liquidated in a contract, and typically it's just part of your damage exposure in a contract, like for example for delay. If the injury is uncertain or difficult to quantify, in other words, it's hard to put a specific dollar amount on it, so you agree in advance, this is what your exposure is. The amount must be reasonable. It must consider the actual or anticipated harm caused by the breach, the difficulty in proving the loss, the difficulty in finding another adequate remedy. And they have to be structured to function as real damages, not as a penalty. Texas, for one, outlaws delay penalties or liquidated damages that are nothing more than a penalty. And what does that mean? There's a lot of case law on this, and I would argue that it's very vague. But it's certainly going to be one of the things you're going to want to argue if that becomes an issue for you. Again, it possesses some contractual advantages to both parties because it establishes predictability on certain types of damages. It also provides a way to serve as a source for limited insurance for both parties. Each party has the opportunity to settle on a sum that they think is something they can live with. So again, it's not like you're going to have to submit this to a court or a jury to determine what is a reasonable amount of your actual damages for busting a delivery date. The second area that we see all the time that is limited is incidental and consequential damages. And this is just one example, but essentially incidental and consequential damages are like punitive damages. They can include punitive damages, anything other than actual or your normal consequential, not your consequential damages. So if you, for example, breach a contract and you know what the total value of the contract is, typically the amount of your actual damages is going to be limited to attorney's fees under Texas law, as well as what's called the benefit of the bargain or the loss of the benefit of the bargain. It does not include punitive damages and some of these other things that arise from the consequence of damages. It's almost everybody wants to exclude incidental and consequential damages. And again, this gets rid of the big bugaboo, which is, even though we have some liability caps now for punitive damages, those situations where you may be exposed to punitive damages, which can be still significant. It can be twice your actuals, and it's a very serious area that you need to look at. The last area is a liability cap. I love liability caps because, like liquidated damages, it allows you to cap your entire exposure under a contract. If I can, I like to get my customers that are particularly the manufacturers of oil-field equipment, to cap their damages or the amount that they are exposed to as the value of the contract. So if you've got a $5 million contract, it can't be more than that. I see someone shaking their head.
Yeah, I've been there where we cap, where they try to cap it at
Yeah.
2,000 on a welder.
Yeah.
And it caused $2 million worth of damages.
Yeah.
I work for companies, the operator.
Right.
Not the service company, so I don't like the
Liability caps.
liability caps.
You're right. Right, no, but I mean, it's obviously a very important issue for you.
Totally understand.
So depending upon which side of the contract you're on and which type of service or good, or whatever the contract is that we're talking about, it can make a huge difference. You may absolutely want to oppose those kind of limitations, or it may be a deal breaker for you not to have them. This is an area.
Just want to
I'm sorry, please.
One thing from
Yes.
from an impact on the insurance markets, and then Brian, I'd like to get him as well, but this certainly has an impact on your umbrella pricing. Anytime you can put some sort of caps, even at a multiple of 3 times the revenues, etc. But all too often we see clients, betting the farm, relatively low revenue and having broad, unlimited indemnifications. And certainly that should be a point of negotiation when you're sitting down with your parties. And it has a direct impact on the pricing of your umbrellas in particular. And we'll talk about this a little later, but you need to take a good look at your internal processes of contract review. Are these things being done in the field without attorney review or senior management review, or do you have some sort of waiver process where there is approval? Because you literally can be betting the whole company on this process, and caps is one significant way to limit that exposure.
Thank you. Please throw something at me if I forget to pause at an appropriate time. This is the area of venue and choice of law is an issue that is terribly underrated, in my opinion. There are so many problems that can occur when you have an unfavorable venue or an unfavorable choice of law. It's not unusual, for example, in insurance policies that they may say that they may have to be litigated under UK law. Obviously, if both parties are in the same state, I want to have that state's law control. If neither party can agree upon where it has to be, then we may drop that point altogether and let it be based upon the facts of the case. Some cases, and this is more on the venue side, but for example in Texas, if you have harm that occurs to a particular well, that's something that pertains to real estate, and real estate or real property under Texas law has mandatory venue wherever that property is located. So what I always worry about is what most litigators can call being local counseled. You have a case where you have to try the lawsuit in Duval County, and if you don't get a local attorney in Duval County to be lead counsel or co-counsel with you, the chances of you getting a fair jury and maybe even a fair judge are greatly diminished. So you want to really think hard about where those cases can be litigated, where you want the case to be litigated, and if it's going to be a particular state, how that state's law may interpret indemnities, for example. So you know, well, if I'm in Texas and I have a blowout, I can count on XYZ. But the contract stipulates, and both parties can agree to avoid a state's law on a particular issue. They can say, we're going to do this no matter where the loss occurs under Minnesota law. And so you need to make sure what the ramifications are of that particular issue. This could be my number one issue, which is litigation versus arbitration. And even though as a litigator, I can do either one, I will tell you that I hate arbitration. I hate arbitration. And the reason I hate arbitration is there are no protections anymore. If you get a frivolous ruling, you get a ruling that is 180 degrees different from the law of a given state. The federal protections that used to allow you a remedy if the ruling is so contrary to law that the ruling should be thrown out, no longer exist. So if you go with arbitration, you need to be aware there's no possibility of appeal. If you get in front of a state district judge and you get a terrible decision by a judge or a jury, at least you have the hope that a Court of Appeals or the Texas Supreme Court or whatever state you're in will give you a ruling that comports with the law. That's not, I know why people choose arbitration, although I will argue that some of the benefits are not as good as they used to be. And that those benefits are relaxed rules of evidence, cost, more expedited proceedings. There are many times when that's no longer the case, where an arbitrator or a panel of arbitrators will sit on a decision for months, where you conduct some limited discovery, but the whole process can take easily a year, not a month or two. I'm not talking about the time that you're in court or in front of that arbitration panel, but some of the benefits that used to be there are not nearly as strong as they used to be. If it's impossible for you not to negotiate, or let me say this another way, if you're required to get a particular deal where the other side insists upon arbitration, make sure that you've got some exceptions to arbitration, such as injunctive relief, where you're talking about infringement of patents, trademarks, copyrights, or trade secret information. That's the kind of thing where you would like to have the ability to go into court and get some immediate relief. I see this gentleman smiling over here, and I don't know if you have a comment about this or if this is an area of issue that on some of your contracts. Yeah, okay. You thought of something that made him happy and probably had nothing to do with this. So I'm sorry I picked on you. My apologies. Okay. I do want y'all to speak up though if you have questions. There's a brand new case, and it was a case that our firm was involved in, that I in particular was involved in, this is breaking news for most people, which is Enterprise Field Services, which is the Enterprise natural gas pipeline system that runs across most of the Southwest, versus BP America. And I personally think the decision was ill-informed and creates a tremendous amount of uncertainty. In this case, I represent BP in this matter, we were litigating a 20-year-old contract between three parties that had a huge financial impact. And the dispute, in our opinion, was exclusively with that contract. The other side brought in another contract. And by the way, these parties have got at least 100 or 200 contracts between them governing all different kinds of services and fields and so forth. But the other side brought in another contract, in my opinion, completely unrelated to the facts in our particular case. And that contract contained an arbitration provision. Our argument was, Your Honor, this is 20 years after we signed this contract. It has nothing to do with the gas gathering, strike that, the gas processing aspect of this particular relationship. And there's the fundamental constitutional principle, state and federal, that parties are entitled to negotiate and be able to rely upon contracts. The Court of Appeals held that if one party, and this later contract involved two parties, not the original three, so it's not the same people. It was generally the same part of the country. And that contract, the court said, touches upon your contract. And your guess is as good as mine as what touches on means. I think they meant it involved some of the same parties in the same geographical area. Then that new contract trumps the negotiated agreement of the parties that's 20 years old. So where they had agreed we are going to litigate disputes, new contract says, has an arbitration provision. Problem I see here is that if you have a company that's got many contracts with many different people and many contracts with a number of those people, and one of those contracts, somebody slips in an arbitration provision, you can no longer count on your ability to litigate certain types of disputes. Maybe you're in love with arbitration and that makes you happy. But because of the concerns that I've already reiterated about the non-appealability of any kind of decision that comes from an arbitrator, this causes me a lot of angst. I think it throws a big monkey wrench into many contracts in our state. We asked the Texas Supreme Court to speak on this because they've never directly spoken on it, and they refused to do so, which basically allows this decision to stand as the highest ruling in our state. I think I know why they did that, and that is there is an overwhelming predisposition by the Texas Supreme Court in favor of arbitration because of the huge number of cases that are being appealed out of state courts. But I don't think that trumps our constitutional right to be able to rely upon our ability to contract. Insurance. My colleagues at Wortham can talk about this at length, but being adequately insured can be your best hedge against many of these unforeseeable risks. And so I almost always ask my clients to have them review their indemnification provisions, but maybe some of these others as well, with their agent. And some of these agents that I've met with various firms are phenomenally well equipped when it comes to understanding the ins and outs of indemnities, liability caps, and so forth, and have taught me quite a bit over the years. But the main thing you want to know is, if I agree to this, am I going to be covered? And they may say, no. Or they may say, yes, but, or we're going to charge you more. But if you want that insurance coverage, it's very important to have your carrier as well as your lawyer look at those provisions. I think we all know by now that there are many provisions that are accepted for most of the policies of insurance: intentional torts, contract disputes, even some forms of indemnification. And I don't know if y'all would like to speak to this.
Well, I want to make one comment. You indicated that you should have your attorney in the insurance company review the specification of the contracts. It should not be the insurance company, it should be your insurance agent. I don't think there's any insurance company out there who's going to review individual contracts.
I agree.
Or risk management.
All risk managers review them, of course they do.
If I said that, I misspoke. I certainly was referring to agents. The last main topic I want to talk about that I look at is confidentiality. You can only limit some types of confidential or proprietary information that's not otherwise covered, let's say, by copyright or patent, by contract. I'm not talking about trade secrets. I will talk about them in a second. But there are some areas, software, computer programs, photographs, recorded memoranda, other things that are maybe very important to your business that you don't want to get out, that you can only protect yourself through confidentiality provisions in contracts. They're not otherwise specifically addressed under law.
Maybe I'd like to just make
Yeah.
one comment. Regarding confidentiality, years ago there really wasn't a good insurance solution, but now there is. A lot of these cyber risk policies will cover breaches of security that result in a confidentiality, whether it be in electronic or paper form. And also when there is an infringement on the intellectual property. These policies have come a long way to covering everything up to and including copyright infringement. But once you get into the area of patent infringement, then there are some specialty products for that. But we're seeing a lot more contractual language wrapped around the protection of intellectual property. And quite often, frankly, when I see these contracts across my desk, that's practically never addressed or focused on. But the damages can be significant, and as you can speak as an attorney, defense costs in the intellectual property area is quite expensive.
Astronomical, especially, Jim, if you get into the trade secret or patent area. It's not at all uncommon for parties to spend $1 or $2 million at a minimum on both sides, and that the expert cost alone for the parties typically are in the $400,000 to $500,000 range. And as you may know, a lot of those cases turn upon the testimony of experts. So, as usual, there's an insurance product that the insurance industry has adapted to help address this particular risk, and I'm glad to know that. I did not know that. Trade secrets have been an area that heretofore in Texas were covered by jurisprudence or case-made law, the common law. Now they are, for the first time since September 1, protected by statute. Texas was the 47th state to adopt the Uniform Trade Secret Act. And good news is they not only adopted it in all important parts, but they expanded its application in several areas that are very helpful for companies and provide greater protection. They have expanded the definition of a trade secret. They have eliminated the continuous use requirement. It used to be that if you didn't use a trade secret, you could lose the protection. Sometimes parties will develop some cutting edge technology and they'll float it in the marketplace. It's just not the right time, and they pull it back for use later. They could have lost that prior to this law. This allows them to reintroduce that law and not to lose the trade secret protection. We're going to talk about this next one at some length because it is so important. They now extend injunctive relief to threatened, not just actual misappropriation of trade secrets. You can get attorney's fees if you're the prevailing party. Couldn't do that before. The new law allows reverse engineering, but it provides a way to protect yourself through a license agreement, and the damages model has been greatly expanded. Under the Texas Uniform Trade Secret Act, or as you see, this an acronym of TUTSA, in addition to the areas in black that we've always had case law protection under, it's now clear that we have statutory protection for all of those areas, plus your company's financial data, and lists are information that would identify your actual or potential customers or suppliers. There are certainly cases out there that have held and have given us some confidence that customer lists are protected under the prior Texas case-made law. This makes it absolutely clear. And it's not just a list, in my opinion. It extends to producing documents, for example, or having someone illegally produce documents that would, in and of themselves, identify who your customers are. Two things that you're supposed to do under the new law to ensure the law's protection are make continued efforts to keep the trade secret secret. It doesn't mean that just because you have trade secret protection, you can now publish information about that trade secret, that Coca-Cola formula, and still have that protection. You have to protect the actual or potential economic value from not being disclosed to others when the trade secret has independent economic value. As we've talked about, there's no continuous use requirement anymore. Again, you still have to maintain the secrecy of the information that you have developed that is trade secret. But the biggest area, and this is truly huge, is that it provides injunctive relief and damages protection for actual and threatened misappropriation. Many other states have case-made law in an area which is called the inevitable disclosure doctrine. Maybe to supplement their state's Uniform Trade Secret Act, or where they don't have the Uniform Trade Secret Act. And that the proposition behind the inevitable disclosure doctrine is you have a scientist working in a specific area, high value research. He goes to work for a direct competitor in the, just to make it ridiculous, in the mailroom. But certainly, if he goes to work for a competitor in an area that's tangential to that research, under the inevitable disclosure doctrine, it is presumed, you have a case-made presumption that someone who's attracted to another company that's a direct competitor, trying to develop technology like yours, that this person inadvertently or intentionally will disclose at some time. Under the Texas Uniform Trade Secret Act, this essentially statutorily adopts that presumption. So if you have an employee, even if they're not under a non-compete agreement, and they had access to very sensitive information, and they go to work for a competitor, under this act, you can enjoin the new company from hiring them. You can enjoin that company from going to work for a competitor. There is only one case that's been filed that I'm aware of under this act. There have been no rulings yet, but it provides you with a new, very big line of support. I think it needs to be used judiciously in appropriate circumstances. The law says you don't want to use it on low-level employees where there's nothing that really is of value that they could take. We still do have a general body of law and public policy that we don't want to interfere with competition. But this is an area where, again, where it could risk the company or a huge source of money for a company where you now have a source of protection. Lastly, I want to mention, I'm sure there are a lot of people here whose companies or whose clients work internationally, and there are other areas, other terms that are very important that we don't have time to discuss. Some of these are international conventions, are codes that various states or the government, federal government have adopted, such as international commercial terms, the Carriage of Goods by Sea Act, which is a federal act, BXC, the Bureau of Export Affairs, that says you can only export certain types of goods to certain countries. The UN Convention on Contracts for the International Sale of Goods. Everybody knows the next one, which is the Foreign Corrupt Practices Act. And although people are not, companies are not being, they're being indicted criminally, the Justice Department has not heretofore been sending people to jail, but it's a distinct possibility. They're talking more and more about doing that, and as you know, the FCPA governs the providing of benefits, and it can be through a contractor of yours to a low-level governmental employee of another company where they're bribed, or where they avoid the label of bribery by, for example, in a bid for a particular offshore block, they significantly overbid everybody else, understanding that the excess is going to go to some government official, et cetera, et cetera. So there are many areas that we've talked about. 7 in particular, I could talk about nuances of even things like force majeure, depending upon where you flip your recitation about certain types of acts that you want to say are excluded from liability. There's some cases that are very scary under force majeure, but I've given you my top 7, and I hope that's been beneficial.
Just very briefly on the international, one point that I do want to point out that obviously when you're dealing in multiple countries, being in compliance with those local laws is absolutely critical, and having some help in those countries. And we do have a network to assist you in getting compliant. I also want to mention the fact that when criminal issues are assessed against some of your directors and officers in country, though the directors and officers liability policy, you want to take a look at your policies carefully about how that addresses the international. because though these policies aren't really designed to handle criminal issues, but the allegations themselves, and correct me if I'm wrong, but there are certainly defense costs including in those coverages where you can afford some protection for your people. So,
Enormous.
yeah, so be mindful of that. There is some protection. David, did you want to kind of elaborate any more on that?
Well, on FCPA and UK bribery, there's some products out there as well for that. If you're a publicly traded company, you're really only going to get covered if there's a securities claim that comes out of that investigation itself. So there are some actual direct products. They're pretty expensive right now, but they're out there to go a little bit beyond what Jim's saying on local policies in one jurisdiction.
Yeah, that's important. It's quite often missed that some of those can be addressed. Real briefly, again, swinging back around to look at the impact of indemnifications on your insurance policies. Obviously, what we want to try to do is to try to design our products in such a way and design our indemnifications in such a way that the indemnity is completely covered by the policies. Unfortunately, as a matter of course, that's a rare event. Usually it's going to be a situation where the scope of the indemnification is broader than what is available in the insurance contract. And there are various verbiage that can be brought in. That the limit of the indemnification, for example, is no broader than that of the availability of collectible insurance. But unfortunately, that's something that is usually pretty hard pushback on, and you can't get that. And so it's a fact of life that the scope of these indemnifications are quite broad. Let me just give you a tip. I see this all the time. Anytime you see in your contract that it covers any and all liability, you can bet that your indemnification has gone well beyond the scope of coverage, and you may be looking at a very bad result, because now you're looking at picking up anything from patent infringement to professional liability, whatever. There is no, it's defined, and that indemnification wording will drive a bad result for you. So one of the things we're talking about is this is, and unfortunately in our business, all too often we don't see the contracts till after they're executed, and then we're scrambling to do what we can to respond from an insurance standpoint, but it's really only so much you can do. Then we send out the proverbial chicken language that, subject to policy terms and conditions and helping our customers, and you're in a defensive posture there because you can only do so much with these insurance products. So please be mindful of that as you go forward. Brian, did you want to talk a little bit about what exactly is found?
Sure, I'll make it quick. I'm glad to know that the 200,000 certificates I issued last year have chicken wording in it. It's interesting, Jim. Never heard that one. It basically, when you have a contract in place and you put the indemnity provisions within your contract, you usually ask for the additional insured status from a third party. And our key point of this is that we know that there's exclusions within your CGL policy, and then the exception to that is the insured contract. But there's a lot of additional insured endorsements that amend the definition of an insured contract to exclude the sole negligence. And our point is you want to make sure just because you have it in your contract that they have to require this information. I would highly suggest when you do get a certificate, you ought to review the actual endorsement. Second thing is, the next slide, is the indemnity wording. I mean, it's kind of repetitive motion here, but in a real world, a perfect world, it'd be great to be able to limit the indemnity provisions of your policy to the four corners of your insurance policy. We know that's not reality, but it would be great to do that because, repeating what Jim said, I've seen many contracts where contracts will extend to anyone and anybody. Well, that's great within your contract, but your insurance provisions don't allow that. So the point is if we could, in the perfect world, we could go back and create indemnity provisions to comply with the four corners of your policies. The reaction of your insurance policy at the time of claim is going to be more positive.
Just briefly, Brian, what is the impact of underwriters? Because from time to time we do send these contracts to the underwriters to look at, because we're looking to expand the coverage where we can. For example, a policy that we may pick up, we obviously avoid this like the plague, but it may absolutely, it may exclude sole negligence. that you're assuming in the contract? And what's the impact of an underwriter typically when they see verbiage like that?
No. But there's negotiating room, it's always for a fair amount of premium, lowest we can for our clients. There's always negotiating points to remove that sole negligence and offset it. But most underwriters, when you come to them completely and try to pass on 100% liability to them, there's some reaction to it.
Just kind of curious with a raise of hands, how many of you, it really depends on the contract management structure of your respective organizations, but how many of you are in situations where the field is executing the contracts and you don't have a proper clearance system for the approval of these contracts? Anybody run into that? Is that my kind of touching a pain point there?
They may have a policy, but that doesn't necessarily.
And I recognize that risk managers have to be the adult in the room sometimes to say no. And obviously you have to develop some relationships with senior management, and I call managing the politics of the situation, because you're dealing with revenue generators for your respective firms, and you have to step up and say, well, the revenue is X, but the exposure is Y. And you have to make your case for why this is a hazard. And so my recommendation is obviously develop relationships with somebody in the organization, in your respective organizations, that can back you up, because unfortunately the thrill of the deal, the excitement can drive a bad management decision. And that's frankly when you can engage your attorney and your insurance agent to maybe help draft something to help make your case for you. Sometimes an outside third party can be of some help in that process. I feel for you, but that goes on every day. I think that's Brian, the bottom line, I guess?
Well, the bottom line is the more you can shift away from your exposure to someone else's exposure, I think the more favorable the underwriters are going to look upon your contract, i.e. the insurance contract with the premiums. I mean, those clients, and there's very few out there to do, that don't shift any of that risk, insurance companies are going to probably look less favorable from a pricing competition standpoint. Shift as much as you can is what we're saying.
But more importantly, if you remember that first slide, you don't want to have a situation where you're stuck with an uninsurable risk. And again, that can rear its head in the area of personal injuries, in the area of pure financial loss. Typically, these indemnifications, what we like to see, frankly, is that they're restricted to bodily injury and property damage only. That's kind of based on an occurrence. That's where your general liability, general liability policy coverages reside. But when you see, again, any and all liability, it means literally that. And you have now gone beyond the scope of what the general liability policy will typically provide. In terms of a checklist for drafting insurance requirements, I'm not going to read this to you. But this is, my recommendation is take a look at this list, get with your in-house counsel, and draft yourself a good set of specifications that you want from your vendors, and then set up an exception. Yes?
I have a question regarding completed operations. The additional insured endorsements pretty much now, well, they talk about you only get the limit that's required in the contract, but then they also talk about in the completed ops additional insured endorsement. Now they say basically, and maybe they have for a while, but they say only for the term as required in the contract or the end of this policy period, whichever's first. So what's the recommended time period that we should have in our contracts for completed operations?
Brian, you want to handle it?
I didn't hear so many.
I guess the additional true provision and how it addresses the completed operation. And you have a situation that sometimes the contracts are relegated, if I understand your question, were relegated to a particular time period.
Well, the insurance, the ISO endorsement for completed ops, when a contractor has that endorsement, which is one of our requirements, the endorsement itself says that it will only provide that completed ops additional insured protection for either as long as you put in the contract that they're supposed to have it, say 1 year or 3 years. But then they say, but if there is no stipulation of a time period in the underlying contract, then it's at the end of that policy period, as soon as
At
that
the end of the
policy
policy period,
expires.
then I put in your contract as long as you can.
So what is the recommended length of time? I mean, what is kind of a standard?
Complete operations
Yeah.
claim can happen way after the fact.
I mean, you can, okay, if you want to complete operations, I mean, it depends on what you're doing. You're not in the residential world. It could be statute of repose, which in Texas could be 10 years. I mean, that's a hard question to answer from a standpoint of how many length of years, but again, that's something I think I'd review with your legal department, because I don't think insurance, I would recommend a minimum of 10 years because the statute of repose back around a lot of things. Do you agree with that, Randy?
So Brian, if the contractor's going to go back and say, I don't want to do 10 years, where the contractor's policy normally have complete operations for an indefinite period of time, so Julie can say to him, your policy should provide that, you should agree to 10 years.
It could have it, Richard. Depends on, I'd have to read the policy, but yeah, you could.
So that may be some of the pushback in that negotiation.
But unless the contractor's policy has the same endorsement.
What's the contractor's policy that you're looking at?
It could be the statute of limitations as well as the statute of repose. And you've also got the discovery rule, which has an effect of extending when you can bring that cause of action. But maybe you want to carve that out so that you have some understanding of what your exposure is.
Again, real quickly, reasons for requiring additional insured status, Brian?
Well, again, the reasons, also in our marketplace, every contract we review, you're usually required to add someone as an additional insured to your policy. And I'd have to remind all clients that when you add someone as an additional insured to your policy, you can be impairing your limits because they actually have contractual rights to your policy. And it's sometimes talking to clients, it's quite shocking that they actually don't understand that, because you could sign 1,000 contracts and have 1,000 people added as an additional insured to your policy, but every one of those additional insureds could impact your policy limits, and then it could be impacted all the way up to the tower. So our point is you're not going to remove that status, but then at the end of the day, just be prepared that it could impair your limits. And the point on here, backing up potentially unenforceable hold harmless agreements, since the Texas Anti-Indemnity Act was enacted, 2 years ago, January 1st, I don't see that as something that's going to me, the knock for knock and trying to point the big boy, pointing the little fingers at the little guy, it's no longer enforceable underneath the Texas Anti-Indemnity Act. And last thing is, my point in all this whole conversation is, please try to get us involved as soon as possible in your contracts to make sure that the insurance provisions that we certify comply with your contracts.
Where I have seen the unenforceability of the whole harmless agreement come up is where Randy alluded to that in his earlier slides. You just didn't draft it properly. It was bold, conspicuous, and the court throws it out. And, oh my gosh, well, your fallback position is going to be that additional insured endorsement. So you're not done yet. You have that coverage built into your specifications.
Jim, are you saying then if you've got two large energy companies and they have the knock agreement, the anti-indemnity statute is not going to apply?
Well,
you have additional insured status?
I'm talking about this in a broader sense because not all contracts are going to be controlled, obviously, by the anti-indemnification statutes. And so you just, especially outside the oil field. So we're talking about general contracting and et cetera, but that does come up. It's a nice, easy fallback position to have, and you should have it built into your contracts. In terms of additional insured endorsements, the only thing I'm going to say here is again, beware that there are many types of additional insured endorsements. Some will include or exclude sole negligence. They get the contract specifications and the contracts you're executing, especially in the indemnification, basically lays some sole negligence responsibilities on you for the other party. So make sure you do get the agents to make sure that your additional insured verbiage you've committed to is in compliance with the policies you're actually carrying. Briefly, and I'll wind this up, and insurance requirements, I already talked a little bit about that, and basically it's these last two positions here. Line management often has the authority to execute contracts. Obviously, that is a potential problem and risk. You need to be an advocate to make sure that you have the proper contract management protocols in place. And And then it should be who reside in the area, the risk manager, legal counsel, the project manager. But all too often, the organizations, they've decentralized that process, and it does present problems, let me assure you. And then you're battling with your carriers to try to find coverage in a situation that you've got an identification that's gone well beyond the scope of the available coverage. I'm not going to go through this, but basically this is a workflow contract review chart that's in your folders that you can build this into your respective organization, something one of my, that you might have to put into play. Just to announce, our next seminar is going to be the 2014 Insurance Market Review Seminar. That'll be on Tuesday, January the 14th, and just letting you know it's going to be at the Houston Country Club. We do this once a year, and it is our best crystal ball of what to expect in the upcoming year. So it's usually a worthwhile event to attend. And contact somebody at Wortham and get set up and registered.